The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority from the state in which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof escaping into another shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. Section 3. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned as well of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Section 4. The United States shall guarantee to every state in this Union a republican form of government and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Article 5. The Congress, whenever two-thirds of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of two-thirds of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of three-fourths of the several states or by conventions in three-fourths thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the ninth section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be valid against the United States under this Constitution as under the Confederation. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby anything in the Constitution or laws of any state to the contrary notwithstanding. Senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same, done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and the independence of the United States of America, the 12th, in witness whereof we have hereunto subscribed our names. G.O. Washington, President and Deputy from Virginia. New Hampshire, John Langton, Nicholas Gilman. Massachusetts, Nathaniel Gorham, Rufus King. Connecticut, William Samuel Johnson, Roger Sherman. New York, Alexander Hamilton. New Jersey, Will Livingston, David Brearley, William Patterson, Jonah Dayton. Pennsylvania, B. Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Jared Ingersoll, James Wilson, Goove Morris. Delaware, G.O. Reed, Gunning Bedford Jr., I assume, John Dickinson, Richard Bassett, Jocko Broom, Maryland, James McHenry, Dan of St. Thomas Jennifer, Daniel Carroll, Virginia, John Blair, James Madison Jr., North Carolina, William Blount, Richard Dobbs Spate, Hugh Williamson, South Carolina, J. Rutledge, Charles Coatsworth Pinckney, Charles Pinckney, Pierce Butler, Georgia, William Few, Abraham Baldwin, attest William Jackson, Secretary. In convention, Monday, September 17th, 1787, present the states of New Hampshire, Massachusetts, Connecticut, Mr. Hamilton from New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Resolved that the preceding Constitution be laid before the United States in Congress assembled, and that it is the opinion of this convention that it should afterwards be submitted to a convention of delegates chosen in each state by the people thereof under the recommendation of its legislature for their assent and ratification, and that each convention assenting to and ratifying the same should give notice thereof to the United States in Congress assembled. Resolved that it is the opinion of this convention that as soon as the conventions of the United States shall have ratified this Constitution, the United States in Congress assembled should fix a day on which electors should be appointed by the states which shall have ratified the same, and a day on which the electors should assemble to vote for the president, and the time and place for commencing proceedings under this Constitution. That after such publication should the electors should be appointed and the senators and representatives elected. That the electors should meet on the day fixed for the election of the president and should transmit their votes certified, signed, sealed, and directed as the Constitution requires to the Secretary of the United States in Congress assembled. That the senators and representatives should convene at the time and place assigned. That the senators should appoint a president of the Senate for the sole purpose of receiving, opening, and counting the votes for president. And that after he shall be chosen, the Congress, together with the President, should without delay proceed to ex- execute this Constitution. By the unanimous order of the Convention, George Washington, President, W. Jackson, Secretary, and there's an asterisk here. Language in brackets has been changed by amendment. The amendment, take two. The amendments to the Constitution of the United States is ratified by the states. Preamble to the Bill of Rights. Congress. The United States has begun and held at the city of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the ends to beneficent ends of its institution. Resolved by the state and House of Representatives of the United States of America in Congress assembled two-thirds of both houses concurring that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by three-fourths of the said legislatures, to be valid in all intents and purposes as part of the said Constitution, semicolon viz. Period. Articles in addition to and amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the fifth article of the original Constitution. Note, the first 10 amendments to the Constitution were ratified December 15th, 1791, and form what is known as the Bill of Rights. Amendment 1. Congress shall make no law respecting of an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Amendment 2, a well regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Amendment 3, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or, hmm, sorry, let me take that one more time. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject, for the same offense, to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal cases to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re examined in any court of the United States than according to the rules of the common law. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Amendments 11 through 27. Amendment 11, passed by Congress March 4th, 1794, ratified February 7th, 1795. Note: a portion of Article 3, Section 2 of the Constitution was modified by the 11th Amendment. The judicial power of the United States shall not be shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state. Amendment 12, passed by Congress on December 9th, 1803, ratified June 15th, 1804. Note: a portion of Article 2, Section 1 of the Constitution was changed by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding three on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the votes shall be taken by states, the representation from each state having one vote. A quorum for this person shall consist of a member or members from two-thirds of the states, and a majority of all states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them before the fourth day of March next following, then the vice president shall act as president, as in the case of other constitutional disability of the president, asterisk, superseded by Section 3 of the 20th Amendment. Continue. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the two highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of two-thirds of the whole number of senators, and a majority of the whole number shall be necessary to a choice, but no person constitutionally ineligible to the office of the president shall be eligible to that of vice president of the United States. Amendment 13, passed by Congress January 31st, 1865, ratified December 6th, 1865. Note: a portion of Article 4, Section 2 of the Constitution was changed by the 13th Amendment. Section 1. Neither slavery nor involuntary servitude, except as punishment, except as a punishment for crime whereof the property shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have the power to enforce this article by appropriate legislation. Amendment 14, passed by Congress June 13th, 1866, ratified July 9th, 1868. Note: Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. nor deny any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive, and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age. Hang on, this is a asterisk. Changed by Section 1 of the 26th Amendment. Continued. And citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in each state. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously been taken and having previously ugh, taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. Amendment 15, passed by Congress February 26, 1869, ratified February 3rd, 1870. Section 1, the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2, the Congress shall have the power to enforce this article by appropriate legislation. Amendment 16, passed by Congress July 2nd, 1909, ratified February 3rd, 1913. Note, Article 1, Section 9 of the Constitution was modified by the 16th Amendment. The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Amendment 17, passed by Congress May 13th, 1912, ratified April 8th, 1913. Note, Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have one vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. The amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes becomes valid as part of the Constitution. Amendment 18, passed by Congress December 18th, 1917, ratified January 16th, 1919, repealed by the 21st Amendment December 5th, 1933. Section 1, after 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States, and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress. Amendment 19. That's 19. Amendment 19, passed by Congress June 4th, 1919, ratified August 18th, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Excuse me. Congress shall have the power to enforce this article by appropriate legislation. Amendment 20, passed by Congress March 2nd, 1932, ratified January 23rd, 1933. Note, Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Section 1. The terms of the President and the Vice President shall end at noon on the 20th day of January, and the terms of the Senators and Representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall begin. Section 2. Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall, by law, appoint a different day. Section 3. If at the time fixed for the beginning of the term of the President elect shall have died, the Vice President elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President elect shall have failed to qualify, then the Vice President elect shall act as President until a President shall have qualified. And the Congress may by law provide for the case wherein neither a President elect nor a Vice President shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. Section 4. Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose as President, whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons for whom the Senate may choose a Vice President, whenever the right of choice shall have devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislature of three-fourths of the several states within 7 years from the date of its submission. Amendment 21, passed by Congress February 20th, 1933, ratified December 5th, 1933. Section 1 of the 18th article of the amendment to the Constitution of the United States is hereby repealed.